Hello, welcome to Fun Stats. Today's topic is contracts and damages. Our lives are surrounded by numerous contracts, whether being aware or not. For example, if you purchase groceries at supermarkets, you and the store are involved in purchase agreements. If you work, terms and conditions for your job would appear in employment, service, or any other agreements. You're using software would be regulated in license agreements. Then, if we breached our contracts, what would happen? Today, we consider this question. Today's discussion is based on US laws and the efficient breach theories. Let's take an example. You decided to sell your mobile phone to somebody because you already have used it a long time and would like to purchase a new one. Hearing this news, Tom, one of your friends, offered you to buy it for $100. You agreed on this. So, you and Tom have made an agreement, in writing, in which handling over was scheduled 1 week later. 2 days later, Jerry, another friend, contacted you and offered to buy the same phone for $300. Now, what would you do? A. Sell it to Tom. B. Sell it to Jerry.
That's an easy question. $100 versus $300. Of course, I will sell it to Jerry. With that additional $200, I would eat delicious steaks, sushi, and ice creams.
Ha, thank you, Joanna. I like your way of simple thinking. To think simply is actually the key in many cases.
But according to the explanation, I have already agreed to sell to Tom. This is not the stage of talking with many potential customers. Shouldn't I respect the agreement already made? Besides, Tom seemed a nice guy. So, I will sell it to Tom. Oh, by the way, I'm Joey.
Thank you, Joey. Tom's appearance is not essential in this case, but your feeling might not miss the point. The efficient breach theory handles this kind of situation. An efficient breach is a case where one party in a contract chooses to breach an agreement with compensating damages to the other. Why does this happen? As described in the case, this occurs because a party in a contract thinks breaching and paying damages is more beneficial than performing. In the example, you might breach the agreement with Tom and sell the phone to Jerry, as Joanna chose. Why do laws allow this? From Tom's perspective, your action might be felt like a kind of betrayal. If you promised something, you should keep it. Because you have agreed on it voluntarily, based on your free will. That's what common sense tells us. So, for those who chose to sell to Tom, your decision seems ethical. But the problem is that you lose opportunities to make more profits. For those who chose to sell to Jerry, your decision looks reasonable from an economic perspective. But for Tom, this action might be unpleasant. Are there any problems for option B? This is a classical situation, brought about by the efficient breach theory. Let's see the essence. Efficient breach theory first appeared in the 1970s. It became well known in the 1980s by the Law and Economics School of Thought and the famous Judge Richard Posner. According to them, laws should be designed to give people incentives to act in ways that maximize the aggregate welfare of the whole society. Laws are just providing us with the options to perform or to breach with compensation. So, there is nothing to blame, even if you breached contracts, as long as you compensate fair price. Moreover, breaching would be even preferable if performances are inefficient, according to them. For example, if you sell the phone to Tom, the transaction will make only $100 profit. If you sell the same phone to Jerry, it can make an additional $200. Properties should be used in more value-generating ways. By this, the aggregate welfare of the whole society would be maximized. Thus, selling the phone to Jerry is more favorable. Indeed, there are some criticisms to this argument. Some criticize its basis. According to them, you should honor a promise, no matter what situation changed. because you made it based on your free will. Others criticize its application. Understanding the case as $100 versus $300 is wrong, they say. First, possible litigation costs should be taken into account. If Tom and you are involved in trouble, it could leave you worse off. Second, reputational risks should be considered. Though the theory focuses on a one-time transaction, it would be more usual for us to engage in repeated deals in the real world. If your reputation is damaged, you could incur huge losses in the long run. Third, other legal responsibilities could be claimed. For example, under specific conditions, Jerry and you could be responsible for interference with business relations. In conclusion, there seem to be no definitive answers for this case. If you chose to sell to Tom, it would be nice. You might respond to Jerry, "Sorry, I already have an agreement with Tom." Though you would lose an additional $200 opportunity, if you don't care, no one suffers. If you chose to sell to Jerry, you would be a person with economic rationality. You might talk to Tom to avoid later troubles. "Sorry, situation changed. I cannot sell the phone to you anymore." If Tom does not care about this, all parties could reach a happy end. But what if Tom said this? "That's awful. My colleague John is a big fan of Company X, your phone's manufacturer. Besides, your model is rare and valued highly among enthusiastic fans. I have already agreed with John to sell that at $2,000, based on the agreement with you. So, if you cancel the contract with me, you should pay me the $2,000. As discussed, the efficient breach theory is based on the premise that we can measure damages precisely. However, measuring damages exactly is not necessarily easy work. Thus, the issues come down to how we calculate the damages.